Meeting of the Sunshine Ordinance Task Force Complaint Committee. Call of the roll.
Yep, call the roll, please.
Member Hinsey.
Present.
Chair Wolf.
Present.
Matthew Kate noted not present.
Right, absent. And Complaint Committee Chair testify is on vacation, so she's absent with excuse.
Okay. Item number 2.
Yep, item 2.
Item number 2, approval of the August 28, 2018 Complaint Committee minutes.
Motion.
I'll move to approve the minutes.
I'll second it. Any changes or adjustments?
Any changes, Fiona? Member Hinsey?
No.
No. Okay, public comment on the minutes? Seeing no public comment, can we take that by acclamation? Seeing no objection, the item is approved. Let's call the next item.
Item number 4, consent agenda, determination of jurisdiction, file number 18071. All matters listed hereunder constitute a consent agenda, are considered to be routine by Sunshine Ordinance Task Force, and will be acted upon by a single roll call vote of the Complaint Committee to determine whether or not the Sunshine Ordinance Task Force has jurisdiction and to determine if the requested records are public pursuant to Administrative Code Section 6721E.
Are there any items on the consent agenda that want to be severed? Member Hinsey?
No.
Okay. Public comment on the consent agenda. Seeing none, please call the roll.
Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
The motion passes.
We also need to note that Member Kate and Member Tessa are not present and absent for this vote. And can I have the microphone?
It's on.
Wrong one.
I would also like to note that we did receive a request from Ms. Trabeau to read a document into public comment. However, that is not our practice, and we will put the request for public comment to be read into her file.
I'm sorry, public comment for the consent
I'm
agenda?
not sure. She sent us an email requesting that we read it onto the record.
Oh.
However, we don't read documents onto the record.
No. Just make sure that they're inclusive of the minutes and before adjournment, not an appendix.
If she's not here to state her public comment, we don't put it in as a 150-word statement. She actually has to be present before we do that.
Oh, so it's just a written communication?
Yes, that's how we're treating
gotcha.
it.
Okay, sure, fair enough. Okay, let's
Ready
call.
for item number 5?
Yeah, item number 5.
Item number 5, file number 18049, complaint by Robert M. Smith against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
Okay. All right, so we're back again here for this item. Mr. Smith, we're not going to be taking testimony because we already heard testimony. We're just going to review what we have, and if we have any additional questions or items to request, then we will call you up or the respondent at this time. Thank you.
May I just say, sorry.
Sure.
May I just say, you were kind enough to say the last time that the review of documents given to me might proceed, but I just want to make it clear I've gotten utterly nothing from the.
Okay, we'll go through that. The purpose of this hearing is to create a file and to make sure that we have all the documents so that the full task force has a complete file, and we don't waste time asking for additional documents. We do all that work here. This is kind of like the pre-hearing to the hearing, that kind of thing.
You don't need anything from me.
Not at this point. We'll call you up if we do. Okay? Thank you.
Just wanted to note that
Yes.
Mr. Smith had sent a couple of emails that were not included in the packet because it was after the packet was posted online.
Are
I
they
don't-
substantive?
Well, I have them right here.
Well, all right. Well, before you do that, let me just ask Mr. Smith, the emails that you sent, are they substantive as far as documents?
I'm
That,
not sure I know what you mean by substantive as to documents.
as far as, are they like evidence or more discovery?
Should they be part of the record?
Not so much, well, we have some rules, and that has to do with time frame for delivery before the agenda, so that they can be included in the case file. So my question is usually it's within no sooner than 5 days of the meeting. So my question is, are any of these documents, are you supplying documents that are part of discovery? Are they documents that are substantive to your case? Or are they just email communications that?
No, they're part of my case and do not include any documents from the museums since I have none. But they are substantive in terms of my case. They document that I haven't gotten any museum, anything.
Okay, well, if what you will say to us in testimony is similar to what you have, will be what you have written, that's, we'll take that into the record in that way. But
That would be kind.
Okay, I'm just asking if you had any specific records that are part of your case in these communications. Do you follow me?
Records?
Yeah.
Or statements? I don't
Rec-
have any records.
You don't have any records? Okay.
Because I haven't given it yet.
That's fine. That's fine. I just wanted, because it's something that we would have to discuss and then possibly take a vote to waive the rules on if the information was substantive to your case and because it came late.
I see. Are we talking about the fact that, well, I see one set came in on September 17th, so that was timely, but another set came in on Saturday, and that was not timely.
Right.
Is that what we're discussing?
Yeah, I'm asking because I don't know what they are, because they cannot be presented to us after this particular threshold of time.
I understand. Am I given the opportunity to just summarize briefly what's in them? To
Yeah.
be part of the record?
Yes, but
May I do that?
you will, but I'll ask that, I'll call on you in a few minutes to do that, so we can kind of review what we have and the information that did come to us that we had requested from the last meeting first.
Very kind.
Okay? Thank you. All right, so at the last meeting, we requested some information from the museums, which was delivered, I believe, and begins on page, I have it. If it's included.
Sure.
It was included, yes.
Okay. Right, so this begins on page 113,
Joe,
114,
have a
115.
copy?
Yeah, page 113. Got it.
Cheryl, can you give Fiona
Yeah.
a hard copy?
And is that the same document as what's in here? Okay, great. Okay, thank you. Okay. All right, so my review of this, I'm sorry, can you state your name, please?
Sure. My name is Melissa Powers,
And your title?
Manager of Board Relations and Special Projects.
Thank you. Okay, so it's a little confusing, and I'll tell you why. Because Fine Arts Museums is named in 3 independent entities, so it makes it a little confusing. You have the Fine Arts Museums of San Francisco, then you have the Foundation, which is the second one, then you have the corporation. Okay, so it's a little bit confusing here, and but I want to start out with what is a public entity and what is a private entity. Okay, so the Fine Arts Museums of San Francisco, because they're governed by city charter operation, they are a public agency, so they must follow all the rules of sunshine. The Fine Arts Museums the corporation of Fine Arts Museums seems like a subgroup or a sub-entity.
It's a separate entity.
But
It is-
okay, but it says here the COFAM bylaws. Oh, that's the COFAM, the corporation bylaws.
So those last 2 entities are separate private entities with their own bylaws, that they are not the Fine Arts Museums of San Francisco. They are private, and we do recognize that the Fine Arts Museums is a department of the city.
Right.
And therefore, later on in the slide, when we talk about that, we do fully acknowledge we have city employees that are subject to the Sunshine Ordinance Task Force, and their emails are public records. And I do agree that it's gotten confusing in terms of the issues. I think we kind of see this as 2 sub-issues, because as we go forward to the task force, assuming it goes forward, we have COFAM employees, so they are not public employees.
Are there any employees that serve in both organizations or
We have a
both
few that are
entities?
dual-hatted, and such as, I believe our HR director is dual-hatted, so we would take, of course, that into consideration in terms of reviewing emails to look at whether it is a city issue or if they're dealing with a COFAM issue.
And is COFAM, before we get to with regards to, wait a minute, okay, so I'm following through here, and so you start out with the city department, Fine Arts Museums of San Francisco, and then you jump to corporations, but on the top page it notes the foundation. Is there any specific reason that's out of order?
No.
Okay.
We just poor slide deck.
Okay, that's fine. I just because otherwise, I'm just wondering what the connection is between the foundation and the corporation. But we'll get to that in a minute. How is the corporation funded?
The corporation is funded through, we have membership, through household membership, we have donors, we have fundraising, such as, for example, we have the development department does the fundraising, we have people who make donations
Let
to
me
COFAM.
make it easy on you. Are you receiving any city money?
No.
Okay. Are you contracted with the city?
I'm aware of our MOU that we have. In terms of contracts with the city, we have the city employees. There's no contract that I am aware of.
Does the city, do you have any agreements with the city to provide specific services to the museums?
I think it's almost kind of the city provides, they give us an appropriated budget, and that goes to the maintenance, the security, and some of their employees. But there are no contracts that I am aware of, and
So you do receive funding from the city?
the city employees do, yes. And the Fine Arts Museums as a trust department does receive city, I thought you
Wait a
asked
minute.
if COFAM receives.
No, I'm specifically asking for COFAM. The Fine Arts Museums of San Francisco, we are agreed that is a
Yes.
public agency.
COFAM does not get city money.
COFAM doesn't get the same money. Does COFAM have an agreement with the city to provide services, paid or unpaid?
COFAM has an MOU with the Fine Arts Museums of San Francisco.
is that considered an agreement?
There's a memorandum of understanding between the Fine Arts Museums of San Francisco Corporation and the Fine Arts Museums Foundation. There's a memorandum of understanding.
Okay, the reason why I ask that is because there's a specific section of the Sunshine Ordinance called 12L. 12L is the Sunshine Ordinance for nonprofit organizations that have agreements with the city. It could be receiving funding, it could be receiving a loan, it could be providing services in any kind of way,
No, they
that
don't.
kind of thing, you know.
No.
Okay, so, I mean, but having an MOU is a legal
The MOU is
document.
reflective basically of this brief, like outlining what that the city, what the city charter says that they can, basically what I basically have in here, that the city owns the land, and then that what COFAM is, and that what the Fine Arts Museums Foundation. But it doesn't talk about, we're gonna give you this, we're gonna give you that, because the city doesn't fund COFAM, and the city doesn't fund the foundation.
I know, but take funding out of the picture. It doesn't always have to be funding. It could be if you provide service in the museums and you have an agreement with the city to do that, to be either, you know, it could be providing installations, it could be providing renovations, it could, you know, for whatever it is, to, you know, you can think of it things like, you know, Friends of the Library. You know, they're an independent nonprofit, but they're subject to 12L because they have also a memorandum of understanding and agreement plus real estate. They have a real estate agreement for use of a space inside the building. Doesn't have to necessarily be, you know, physical money, you know, passing through.
I don't know if I have the exact legal answer to
Okay.
you for that, for what you're getting at, but in terms of looking at it from the lens of our records, in terms of emails, I see this sort of as a pronged issue at this point, like in terms of whether or not, when we review the emails, our point is that if there are emails between someone who is considered a COFAM employee to a COFAM employee, that would not be subject to the Sunshine Ordinance.
Except if, well, there's a number of conditions on that. Well, we have this new law under a case law called Smith versus San Jose, which requires that any public official or city employee who has information that is considered to be public on private devices or in private accounts are considered disclosable, publicly disclosable. So there's that, but it's also a matter of in what capacity at that time.
Mm-hmm.
Now, it would be a little painstaking to have to go down the road of looking at people's logged hours, staff hours.
Well, no, but, and our COFAM employees are not paid at all by the city. But I understand, and that's sort
But
of.
we're talking about public disclosure of information. It's not, because you said that you have some city staff that work in
We
COFAM.
do, we have
Right.
city staff, and that is kind of to our point in terms of trying to potentially get some narrowing of the subject. Because everyone is under a famsf.org email, which obviously has caused because we've got COFAM employees that have a FAMSF email versus city employees having the same email as them, that we would in essence be looking at everybody's email.
Mhm.
So that's why that last chart, I went in and I talked to payroll and said, can I have all of the city employees? And then I had IT figure out how many emails are associated with their email addresses. And in just 2 months, not even looking at an employee that we know is not a city employee, is 70,000. So to the point of like Mr. Smith saying he has not received anything in the last month, some of it is because we have been working hard to create the
Okay.
presentation.
So I'm
both
not,
the staff-
I hear you. I'm not, we're not here to receive testimony
Okay.
on what you, on whether you violated or not violated. We're not
Right.
here to determine that. We're here to build a case and to determine whether we have enough information so that the task force can get right into it and come up with some decision, okay? We don't want to have to keep postponing, continuing it, because we don't have all the information that we need. So that's all we're interested in today. That's what we'll try to keep this as brief as possible and move it forward. And we're not going to be arguing the merits. We're just going to be trying to collect the information, and whether any additional information has been presented or found that satisfies Mr. Smith's request or not, and we'll take it from there. And then if, sometimes we're able to kind of resolve the whole issue here, depending upon what's been found since the last time we've met. If we just hold on a moment, I just want to fill in Member Kate on where we're at here. So this case was continued from the last complaint committee meeting. We were unclear as to the status of the entities. There are three separate entities here. In the document that you received, it lays out what they are, and so it seems like we've just gotten to the first two. So the first one easily determines that is a public entity. That's the department, City Department for Museums. The second one is the corporation. The corporation is not, we haven't quite gotten to what services they do provide yet, but just to determine whether they may or may not be a 12L organization. That's as far as we've gotten so far. Okay, and the last thing I was asking was just about, is there any crossover from staff, from the public entity to the private entity? Were there any services provided, not necessarily monetary transactions? There was testimony that from Ms. Powers that there's an MOU, and then that's something that we'll have to determine whether that is actually considered a quote-unquote agreement. And there is some definitions for that in the ordinance with regards to agreement, including contracts, funding, things like that.
And when you say determined, do you mean determined in this meeting or when this comes before the full?
Well,
task force?
we want to be able to provide the task force with enough information. So we're going to ask these questions now, so that way going into the task force, it's clear that we can, when we kind of brief the task force on presentation of the case, we can say to them, there are these three entities. Here's the status for each of the entity. Don't get confused and know that this one applies to the ordinance, this one doesn't apply to the ordinance, or applies to 12L or whatever. So that way we don't have to spend a whole lot of time on a fishing expedition during the hearing.
And the request at issue in this complaint was made, though, specifically just to the city agency?
No,
not
it
to
was
the-
made for all three, because that is what's before us, is trying to figure out, where this information needs to come from, and if which entity is required to disclose, which entity is not required to disclose, and if so, they need to disclose what. So the last point we just made as you walked in was that there are some city staff that also work in the corporation, and the question is there some sort of crossover? Does any of their communications then, are they subject to Smith versus San Jose? And, my point was, it'll be very painstaking to go through a process of looking at people's staff hours to see, were they on staff time while they were working at COFAM, at the corporation?
Well, yeah, and just,
Yeah.
and this is where, because I don't see it so much as hours in the sense of like punching, there would be no way in terms of, there's no punching in, punching out as a co-fam, because it's like the director of HR, the director of the museum is dual-hatted. So perhaps the content might be something of their, but there's no, like a city employee will use a punch card or however their payroll is done, and that's totally gone through the city. But there's no necessarily way that those few employees that might be dual-headed, it's an hours thing probably.
I understand, but a lot of times when these things happen, there's a requirement to keep a job log. Like, I worked this many hours on this day, and they don't have to give like 1 o'clock I did this, and at 2 o'clock necessarily did this. It could be like, I worked 4 hours on this day, and I worked 3 hours and on the other thing, kind of thing. There's kind of like a shared log, and the only reason why I bring that up is because if there is commingling, that could be an issue, and it could be an issue. We have to ask legal counsel. This is a little bit of uncharted territory for us, and if you can hold your thoughts, Mr. Smith, I'll give you an opportunity to let us know everything. I'm not going to have a debate here.
And just to your one question, sir,
Yeah.
in terms of, I do know like the language of the MOU does mirror the language in the brief in the sense of using words that the COFAM, we supplement the city annual appropriation, or COFAM supplements, or FAM F provides funds to COFAM, but I'm not, and again, I don't want to misspeak, but I'm not, the terms of the MOU are mirrored in the PowerPoint in terms of anything else being
Okay.
determined in terms
Okay.
of funding.
So what we're going to have to then, it's interesting. So in our legal counsel's memorandum, he infers that these organizations are associated with the museum. And because they are associated, they may be subject under 12L.
And like I said, I certainly, in terms of providing a legal answer, COFAM bylaws talks about that it supports, part of their purpose is to support the museums, but I don't know what would be the legal threshold to determine the 12L.
So maybe it'd be helpful just to explain it a little before we go on. I don't want to take up too much time here. Cost neutral. So 12L.2 A, each contracting agency of the city or any department thereof acting for or on behalf of the city.
No, I would say, I would think I would be misspeaking to say that COFAM acts on for or behalf of the museum. Again, I don't want to misspeak, but
Okay.
I'm not aware of any legal contract. That
Okay.
would-
So let me give you the definition in the law of what contract is for this purpose. Contract means an agreement, however titled, including without limitation a memorandum of understanding, to grant or otherwise provide funds to a nonprofit organization, including funds from another governmental entity administered through the city or any city commission, city board, city agency, or city department for such organizations' operations, new or existing programs, events, performances, capital improvements, or for goods or services provided by or through such an organization to all or any portion of the public.
Well, I probably would have to see the word in front of me,
Okay.
but the city they don't administer the COFAM funds.
But do they provide any funds that COFAM appropriates or administers on behalf of the city?
Does the city provide it?
Does the city provide funds that COFAM administrates?
No.
Can you just explain what the purpose of COFAM is and what's its association is to FAMSF?
Well, its bylaws talk about that it does support the fine arts museums. It does, it works in conjunction. It's a non-charitable trust that helps supplement, because my guess, in terms of going back to the genesis of it, if the city only appropriates so much, it helps support the day-to-day operations of the Fine Arts Museum.
So you provide funds to the museum?
COFAM provides funds to COFAM operations that help support the museum.
And, I mean, okay. Does COFAM operations, do they operate in the museum?
The people are in the museum, yeah.
They're in, so like docents and things like that?
Docents are neither COFAM employees or, docents are private citizens. They are not COFAM employees.
But they're under the auspices of the city. They're given permission or allowance for the privilege by the city, right?
I'm not even,
Okay.
the docents, in terms of what their authority, like, the docents are a private entity in terms of they are not our employees or COFAM's employees.
Okay.
And they are not city employees.
Okay. 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 I'm just trying to determine definitively if there's what the relationship is in order to determine whether 12L is applicable or not. If we can't get to that answer, I'm going to send it up to our legal counsel to have him do it. He seems to infer in his memorandum that there is enough of an association to possibly warrant a 12L. Is the memorandum of understanding in the documents that you sent?
No, I realize after I can provide that to the legal counsel.
Can you? I would just send it to our administrator and they'll distribute it.
Yeah.
Okay, so, all right. Let's move on to the foundation. What's the relationship? It says here it contributes operating funds to the corporation, but there are no foundation employees. No foundation employees.
Correct.
Meaning
Meaning that, like I'm considered a COFAM employee. There's nobody at the museums considered a foundation employee. The foundation is its own separate private charitable organization.
Okay.
They have an endowment fund that they manage,
Mm-hmm.
and they also manage acquisitions, and through that they support COFAM, and the two in conjunction help support the museum, but the foundation is a private organization that they have their own endowment fund, and there's, like on the chart of all the employees, there is no foundation employees.
Okay.
So, does the foundation itself not have any employees?
Well, the foundation has members, but meaning in the sense of we're making this distinction of, is his email a COFAM employee? Is it a Fine Arts Museum? Is it a city employee? There's nobody who's a COFAM employee in that mix.
I'm not necessarily finding enough of a threshold for 12L. I'm going to leave that up to our legal counsel since he inferred it. He may be reading something in a way that I'm not, because mostly 12L deals with organizations that receive money from the city, that not necessarily providing money to the city. But considering that there's an MOU, it's a little bit of a different.
In the MOU, from what I understand, part of that was that the city service auditor division in October of 2016
Mm-hmm.
that recommended that an MOU be made.
Yeah, that's okay. They don't necessarily pay attention to whether it's 12L or not. These things come up by consequence lots of times, and
But
so.
the city is not funding these private organizations.
Okay.
I think that's a germane point.
Okay. Very good. All right, thank you very much. Mr. Smith?
I think I may, if you can hear me,
I can hear you.
be
Yes.
helpful
Yes.
slightly. Without addressing the three silos, as I've taken to calling them, for the moment, and understanding your difficulties with regard to those, and you're getting an opinion from legal counsel, there is one thing that is beyond peradventure clear. It's this. The public museum, the public silo, the one that gets 20% of, well, the whole collection gets 20% of its money from the city. I asked for documents from it. There is no question that that public entity must turn over those documents. It's a public entity. So let's hypothesize, to take my idiotic example, that Victor worked for admin service A and Cheryl worked for admin service B, private contractors to the city whose tasks included giving services to this committee. In the course of their work, they, of course, sent materials to the committee. I come along and say, I want to see the materials committees, please, including anything you got from admin A and admin B. There's no question I would be entitled to those. Now, we've got, in terms of these two other entities, these two other silos, they're giving stuff all the time to the public entity. If all I were asking for, and I'm not, but if all I were asking for are the documents that the public entity only has, there would be no question here that I'm entitled to it, and I haven't gotten one little bit of it. But more importantly, in practical terms, if the other two silos send their stuff to the public silo, Victor and Cheryl send it to you, I'm entitled to it. Thank you.
Thank you. Okay, Mr. Smith, before you sit down, refresh our memories, and maybe something has changed since we saw you last. Have you received any additional or new documents?
Very kind of you to ask, Mr. Chairperson. I still have received no documents at all since the last hearing before the committee. In fact, over the course of nearly 1 year, I have received nearly no documents from this public entity.
And are you aware that they exist?
I would imagine that the museum has documents. They've never said, we're not giving them to you because we have none. They say the reverse. They have too many. Despite the committee's request, may I note, your request, the museums did not provide you with the memorandums of understanding that were referenced again and again here today, even though you asked for them. And please note that their position is now that they won't turn over communications between the private entity employees, whoever they are, and other private entity employees, even though those documents are in the records of the public entity.
So you're talking about communications from the private entity to the public entity?
Correct.
And that are in the possession of the public
Of the
entity?
public.
Got it.
So even if you somehow, and I think it would be a very bad error, but that's my opinion, that I couldn't somehow access the silo A and B, I certainly, or 2 and 3, whatever one wishes to call them, I certainly am entitled after a year, and should have been entitled 11 months ago, to what is in the public museum's files, which they haven't given me.
Okay.
And may I, will there be another hearing before this committee makes a recommendation to the task force? Or not?
Well, this committee tries not to make a recommendation to the task force to allow the task force to come to its own conclusions. Our job specifically is to find out if there's been any progress, to collect any information that was asked for that was not part of the record before. That would help create a more complete record so that the task force has all the records necessary so that they can make a proper decision.
I understand.
So we're not here to do any adjudication, but what we are here to do is a bit of discovery in a public setting.
Right. So
Okay.
the question I would pose in that context, and I'll stop,
Sure.
is how can a citizen, 10 months into this, not have any documents from a public entity, something which is clearly public, they don't deny it?
Okay, thank you very much. Ms. Powers? So have you delivered any documents to Mr. Smith? Take COFAM and the foundation out. You're only here in your public, it's city representation position.
Okay, well, as backdrop, and do you mean from the last hearing, or do you mean in terms of?
I'm sorry, let's just say at all. Has he received any documents
Yes.
that were contained, that are responsive to his request?
Yes, the previous manager of board relations handles also the public request for information. And that's why you see Mr. Jones's name throughout the file.
Right.
And he did provide his findings of what is a responsive document. In terms of the complaint 3, and this goes to, and I addressed it in the presentation, we're not disputing that we understand when a city employee is a common denominator in an email exchange, that is a public record. So that's why it's kind of two-pronged in the sense that we went to Mr. Smith and asked if he could maybe narrow the terms, because it is whether he, and I understand maybe how germane the point might be in terms of how voluminous it is in terms of resources to review those. Is there a subject matter he's interested in? Could we use his name? Could we narrow the search?
But didn't he? You had requested for him to narrow it. You claim, and I have some statements in here that claims that your department had recognized that he did narrow it, but then wanted him to narrow it even more.
He narrowed it by the time, and then they were going through a transition on their email, a migration, which would have made it almost impossible to retrieve all of those emails. And then from that point, we started in this process. So in terms of, on one hand, we're now in this process to determine what is the task force going to decide. Has to be, does there need to be a narrowing? Will there be a schedule given?
We will not make a determination whether there's a narrowing. The public has a right to any documentation that they request. If it's voluminous and it will take a very long time, that's one thing.
Well, and that's
okay. There's that, and we have a process called, kind of on a rolling basis, right? So,
since the last meeting when we talked about that, he submitted another request, which I intend to answer tomorrow or Thursday, the latest. So in the course of
is that similar to this request, or is it
the one he has dated September 3rd that was included?
That wasn't my question. My question is substantively, is it similar to the current request that he has made, or is it a completely different subject?
I would say it's connected to Sunshine Ordinance, public information, communications regarding that.
That doesn't have anything to do with this?
No.
Okay.
I see it as a total.
So then that is not part and parcel to our discussion here.
Okay, but in terms of, because that's a more finite one, I wanted to be able to respond to him in a timely fashion.
I understand.
And then at the same time, we're pulling the emails, we're getting the numbers, we're creating the presentation. It's been 30 days. I mean, in terms of, trying to catch up with the volume of not just the email review, but the work. And, we understand that it was complaint number 3, which is where he asked for, because when he says COFAM to FAMSF, perhaps if we didn't even raise the argument of, COFAM has its employees, then what does that mean, COFAM to FAMSF? Those are entities. Does he mean between employees? Does he mean?
Well, here, okay. Maybe I don't want to take up too much more time here because this is going on a little bit longer than I anticipated. I'll give you an example. There was a case some years ago where there was going to be an event at the Commonwealth Club, completely independent nonprofit organization. But it was going to include some topics that pertain to city government. But nobody from city government was invited to speak. They were all private people, community folks, professionals, nonprofits, and other nonprofits. The city then proceeded to contact the Commonwealth Club to ask them to postpone it on their behalf. And all of a sudden, the Commonwealth Club canceled the event. So some members of the public went to try to find out what happened. And they said, well, we got a call from the city department that asked us to postpone it so that they can send somebody. Meanwhile, there was all this promotion about it. It was a really big deal. So members of the public went and made requests of emails between that department and the Commonwealth Club. When it came to a hearing, that department denied that they had any responsive records. 0. And the complainants showed up with actual emails that the Commonwealth Club gave them between them and the city departments. So that's all I'm saying is there's always communications between private and public agencies,
absolutely.
and those documents must be made available.
Oh, yeah, I'm not
Okay.
denying that they, I'm saying at this point, and maybe after tonight and I get through the September 3rd request,
Okay.
I can catch my breath, and then I can say to the IT, can you please give me all the emails that involve the grounds workers?
Okay.
All the people on that table, because if I'm gonna start somewhere, I'm gonna start with the people that are clearly identified as city employees and using their name as part of the search queue.
Okay, so I don't want to get mired in a request that is not part and parcel to this particular issue. There are, let me see, where's the list here? So there's a request that, I'm just going to run down these requests and ask you if they've been satisfied or not, okay? Request number 1, January 9th, 2018, request for a response to 21 separately enumerated requests for records and/or explanations. The museum's response was some items were questions, not public record requests. Some records requests were for records of the corporation of museum, the COFAM, or the foundation, both of which are private. Okay, the question is does the city department have possession of those records?
Those previous, Mr. Jones gave him what he believed to be responsive documents. So in terms of, nobody said that, in terms
That
of
wasn't my question about what Mr. Jones did or did not do. My question is are the documents that are there records relating to COFAM and the foundation that are part of Mr. Smith's request that are in the possession of the city department?
I honestly, I'd have to go back and relook at the specific item number 1 because there were 22 line items.
But you have not, nobody's provided any documentation?
No, he did. He provided some documentation from the question number 1.
Mr. Smith just testified he received nothing.
He has received items. He has.
What has he received?
Well, I know that he asked for some of the docent rosters. He got those. He asked for, I think in that number 1, in the 22 item, he asked for things like correspondence between us and the mayor's office, or between the museum and the mayor's office. He was provided that. I think he asked for, he asked for 22 things. So I'd have to look through the list of, but there were certain things that he asked for where this goes to the docent program that we don't run the docent program.
So then fine, that's why I'm responsive.
Yes.
Okay, but you need to state to him for each request that he's making, what is responsive and what is not responsive.
But that was provided to him, but I think that the difference is what's been provided to him and whether or not he's happy with the answer. And I don't mean
But that, we're not here to determine how he receives his answer.
Right,
We're
no.
here to determine whether the ordinance has been complied
Yes,
with.
I mean, from the sense of who responded at the time, those records were turned over that were believed to be responsive and as a public record.
Right, so we're here to determine whether that is accurate. Okay? That's what we're here to determine, okay? Because it goes the other way too. Whatever a person who's a city staffer whose responsibility is to comply, what they interpret is to be disclosable or not. That's what we're here. We're here to determine that. And questions, the ordinance allows for verbal release of public information. Doesn't always have to be a written piece of paper. It could be just told to somebody. Like if you call the planning department and say, can I have the project number for this address, and they give it to you. They don't have to provide it to you in writing. They can just tell you over the phone. That is a requirement under Sunshine to provide.
Right, and I believe that Mr., part of the response to, and part of the package was a chart that provided what was and was not, what was given to him. And I think it's page 144 of your package, where he goes through item 1 through 22 of what was determined to be provided and responsive.
Okay. Okay. I was hoping for a little more detail. As to what exactly which documents were provided and were not provided.
At page 115, there's a chart that I believe
I'm looking at that.
Right, and I'm looking at the last package, because the reprint was in the last one, it was page 144.
Okay.
Where he goes through line by line
Okay.
of what he provided.
Okay. Let me ask Mr. Smith some questions on this so we can move on. It's voluminous for us too, okay? But we want to make sure that.
And as I stated in the last hearing, I just need to confirm if a city employee had it. I may have it was from a COFAM employee regarding, I think, perhaps a meeting with Mr. Smith from 2010. And I noted that in the last meeting. And I still need to determine if a city employee has that retained.
Okay.
And if so, we'll give a copy to Mr. Smith.
Okay. That's great. Okay, Mr. Smith, and I'm going to wrap this up because I'm going to ask our other members here if they feel there's enough information to go forward, and if not, then we're going to continue this again until we can get down to making sure that we have everything that needs to be asked for, because I can just imagine, as voluminous as this is for us to go through, and with all the different entities involved in what you're asking for, that it will be a very long evening for the full task force.
Can I say one thing that may be helpful in that regard? At some point, you will see from their own emails, probably 10 months ago, I don't know exactly, they said, they didn't make an objection. They said, we will provide you these materials on a rolling basis. There's no question they said it. They have never given me anything on a rolling basis.
Right. So here's the thing. So I'm looking at, because this was not, the people that actually effectuated this are not here anymore, that, and you have other people now.
You mean
Mr. Jones, yes.
Has a different job.
Right. So, you have other people that have to kind of pick up the ball where it left off. They have to learn it and understand what it is. On page 115 is a pretty cogent chart of what your request was based upon 22 requests, and what was provided or what the response was. And most of these says no responsive records.
I don't have this page 115.
It's in the agenda packet. F was, that's part of the public record. But there's a lot of documents here that they say are not responsive, and I want to ask you what you feel like what they should have or not have that we can kind of get more focused on. I'm not interested in asking you to narrow your request, but based upon your request and these items, what is in dispute here?
Well, number two, I'm not sure where to begin. If you'd like me to begin at number two, all documents relating in any fashion the identities of the current roster of the Museum of Docents, they replied, they have no responsive records. In fact, I persuaded Mr. Jones to put in the mail to me exactly this roster, and I received it in the mail.
When did you receive it?
We had one conversation with the gentleman and persuaded him to do it, and it was early on in all of this, and that was when he said, it's locked up, and I said, get a janitor, open the office, and send it to me, and he did. So this is untrue, that they have no responsive records. They had it. They mailed it to me.
But by the same token, Ms. Powers claimed that docent program is not really part of the museums. It's some separate independent agency.
Well, that's, I'm afraid, an extraordinarily weak legal argument. I'm not sure you want me to explain why. They support the docent program. The docent program is on their website. Their managers of the program are on the website. They're on the premises of the museum. They're housed there. Do you want me to go on, sir?
No, that's fine. I mean, that's fine. It gives us something to consider. Thank you.
Selection of the docents, this is the same thing. If the docents have communicated in any fashion with the public entity, or by my argument, any of the other two entities, I'm entitled to those documents, clearly. And they haven't said that they don't. Their argument is two of the silos are not public, which I don't think will get them where they wish to go, and your counsel has preliminarily indicated that. When they say they're saying one silo has no responsive records. I'm asking for the museum. Mm-hmm. And by the museum, they're sitting there on public land getting 20% of their total revenue from the city. Now that revenue is flowing to these two silos that are doing the work. It has to be. The former city attorney quit the board because of the lack of transparency of the financial data.
But
she couldn't get it.
But we just heard their testimony that they received no money from the city.
I heard it. I'm afraid, sir, as a cynical old reporter, I cannot believe it.
Okay.
I want to see the documents.
Okay.
It doesn't make sense.
Okay.
What happens to the 20% of their budget that the city gives them? What do they stick in the cafeteria?
So what, did you ask for a budget? I see.
I can't remember.
I'm looking through here. I see contracts or agreements. I see attorneys engaged.
What I would imagine such information would appear in these memoranda of understanding between the silos and the museum, mm-hmm. which I've never seen, and with respect, you've never seen.
All right. I'm going to stop here because there's a lot more than I think that is not being detailed in order for us to have a full understanding of what we can provide. Sure, Ms. Powers.
One point I just wanted to be clear on is that there is a COFAM employee who is a liaison to the Docent Council program. The Docent Council program, they are a private entity. So when Mr. Smith refers to they're on our website, they have their own website, and it does have...
Yeah, I know, Ms. Powers, but the thing is nobody gets to operate in a public building, in a public program, without some permission from the city.
The docents, they don't... they support the museum in the sense that these individuals are docents and that they are at the museum, but we have numerous supporting organizations that help support the museum.
No, I understand that, but people can't just go into a city park and start gardening. They have to get permission from the city. They almost have to be part of a gardening program, volunteer gardening program, which means that it's sanctioned by the city and they have permission to do it. Otherwise, you can't just go around digging up the flower beds and planting your own stuff.
And just to the point about the rosters that he said he got Mr. Smith, Mr. Jones to send him, I believe Mr. Jones had to go to the docents to get those particular items.
I understand that, but still, any relationship that outside entities have with a city asset, there has to be some documentation. And that's what Mr. Smith is asking for, simply.
Well, he's asking for documentation regarding like their applications and things like that, but the docents, the docent program, they review the applications and they.
I understand that, but he's only asking for items that are in your possession.
Correct.
And if they're not in your possession, okay, fine. But
Right.
if he's trying to find out how that program works.
Absolutely.
Okay? So, and he wants to know what the relationships are. Okay? So the question is what documents are available that he can have, that every and all documents that you have, that even if they're protected by some area of the law and they can be redacted, unless the law says they can be withheld completely, like some investigation records or something like that, personnel records, things like that. That's a different story, okay? But still, knowledge that records exist is the same as public disclosure, giving them the records. Okay, and if they don't exist, okay, like a receipt from a restaurant that a person on the board of COFAM has, that's not a document that exists in the city universe. So that's going to be unresponsive.
Right, and that's what I'm saying, like, some of these things were, like, number 5, Mr. Jones, I believe, had to work with someone from the docent council program to give any information to Mr. Smith. So when he says he has no responsive records referred to COFAM, that's what I'm saying, like, there are certain things we don't have, and that what Mr. Jones.
That I hear you. I hear you on that. Okay, that's fine. Okay, it is. If you say that those documents don't exist, oh, first of all, look, this is not a venue that requires for you to take an oath, and we do not have enforcement power to the level of a court or the ethics commission to compel you to provide the information. We do have the authority to, if the documents exist, to compel you to produce them, if there's knowledge that the documents exist.
And if they're a public record.
Well, that's what this committee is here for, is determine which records are public and which records are not. If they're in the possession of the city, they're public. Unless you can provide us with a reason, a citation of law that says that is not disclosable.
Well, I'll have to, like you said, in terms of, because Mr. Jones is in here tonight, defer to him as to what, at the time, he said, we have no responsive records, as opposed to what he was eventually able to get from the docents.
Right, so that's the thing. If Mr. Smith came to us and found some evidence of a document existing that you have, and then you say it's unresponsive, then there's something for us to go on. If you're telling us, if he doesn't have something like that, and he's like, it's logically, there's got to be something in order for these people to be in that building and working, and the city has specific policies around gender equity or the list of civil rights that are protected, then is the city requiring this program to be in compliance properly, and how are they proving compliance? Those kinds of things, so that those documents have to exist. Or maybe some other department is the one that reviewed it. Which department? Then it's up. The ordinance also requires you to be able to help him find the person that does have that information. Okay? So that's kind of the process. I mean, if somebody comes to you, you have the information, they get it. If you don't have the information but somebody else does, here's their contact information, or let me help you get in contact with them. And then it goes down the line like that.
I understand, and I,
Okay.
you know, in terms of, I can only go by what he has in the chart, in terms of whether or not he, worked with the specific liaison. My last point would be that we would not give Mr. Smith a document that we believed fell under what Mr. Smith was.
I understand. The question is whoever's doing that work, do they actually have knowledge of that document? It makes it tough when one person had knowledge, no longer with the department, and now somebody else picks up.
Right, no, he's still there, and I mean,
Okay.
I think if he was here, he would stand by his answers.
Okay.
But as we're going forward, if there's, like I said, anything that comes to my attention that we have, that we've been retaining, that I think would be responsive, similar to when I was preparing for this and I found out about that letter, then we will, of course, provide what we think may not have been provided previously, that perhaps should have been.
Okay. Very good. Thank you very much. Mr. Smith, I'm just going to, as I'm running through this list, I'm just only going to point out not what is unresponsive, because I think we're going to have to make a decision about that, but what was responsive. So number 1, it says
Excuse me, let me borrow,
he needs that page again.
so I can follow you, sir. Do you have, lists?
It's page 115.
Yes, sir.
Okay, so on page 115, so number 1, did you receive anything there? It says you received the most recent application from yourself in 2017.
I did,
You did receive that?
yes.
Okay, so that was a responsive to your one request. Okay. Number 9.
They just referred me to their,
Was that responsive to your request?
no, because it doesn't say anything about compliance or non-compliance.
Okay. So in your mind, it was unresponsive?
Correct.
Okay. Number 12. Maybe this is actually probably not responsive.
Non-responsive on its face.
The reason why is because it's regarding complaints.
Right.
Complaints may be protected.
They can redact the name of the complaint?
True. And they didn't necessarily state a citation of law that would protect it.
Right.
Okay.
Nor did they disclose whether there were any.
Okay. Number 14, board minutes. Now, you're talking about the museum commission? I mean, the
Well, there
board
were
of trustees?
Apparently, I would assume there were 3 different boards.
Well,
And-
your request was specifically, so your request was to the city department. It was not to the,
No, it was to all 3.
I understand that, but since they are not a public, those other 2 are not public agencies. As you stated earlier, the city department may, or quote unquote, should have some of these documents from the private entities. They may not have the minutes from those other 2 entities. It may not be a requirement for them to have it.
Well, they say they post them. So they must have them.
The Fine Arts Museums of San Francisco board's minutes, but not the other, not COFAM or the foundation.
Oh, I see, sorry.
Okay? So that's the public entity is posted.
Yeah,
Okay, so
although,
that's not-
I don't mean to agree that the minutes of these 2 other entities are not susceptible to public request. I understand your point, sir.
Yeah, they can be gotten through other means because they're nonprofit organizations. There's a whole set of rules for that, independent.
Right.
Number Okay, let's see, number 17. So that's, looks like well, they didn't provide you any documents, right? For number 17?
Right,
Documents regarding gender bias training?
right.
Okay, except
They
is
told
required is extended to our video course. So we know about this because we all have to take this same course online. It's a requirement of all city employees and commissioners. And there are certificates of completion when you're finished with those. So there is that. And I think it's publicly available. I think you can watch it if you wanted to.
Thank you for telling me.
You would probably contact the city attorney's office for that.
But number 19, where I asked for communications from the mayor's office
Right.
to the museums over 6 months, just 6 months,
Right?
I got one thing, which I'm sorry, but I just find it difficult to believe. It's about earthquake preparedness. So the mayor of this city corresponded with this public entity once, and it was about earthquake preparedness. That's what I'm asking to do.
Okay. So, okay.
May I just say,
Mhm.
you know, when I was a reporter ever so long ago in Washington, I covered the Department of Justice at one point in the FBI, and I filed Freedom of Information Act requests with the FBI, and I didn't have 1/1000th difficulty in getting responses from the FBI that I am from this museum.
Understood. Number 20 says FAMSF is providing resignation letters of 3 trustees received during the past 4 years. Did you receive those?
I did.
Okay.
Well, I got at least 2 of them, and I guess maybe I got the third, I can't remember.
Okay. And 21, nearly because disclosing complaints is needlessly invasive into details. Yeah, okay, so that goes the
Well,
same for
but-
the other
but
one.
You see, it's not responsive. I asked for gender bias complaints, and they say it's needlessly invasive. That's absurd on its face. They can take off the name of the person.
Mm-hmm.
I'm entitled to see if they got the complaint.
Okay. And, okay. All right, so, all right, thank you, Mr. Smith.
Okay.
Let us deliberate for a few moments, and we've got other people in the room that we want to get them out the door, and we don't want to.
Apologize. It's taking up so much time.
It's okay. I mean, if we have to continue it because it's still unclear to us that we can't create a complete board packet, then we'll do that. But let us confer about that for a moment.
If there's anything I can do
I-
to assist, I would be most pleased to do it. Do you understand? I'm sure the committee understands that I must go through this committee to get to the task force, to get to the ethics commission. And it's my current intent, unless I'm persuaded otherwise by events and documents, that when I get to the ethics commission, I will, with respect, ask them to ask the district attorney's office to look into, to investigate this matter and see if criminal charges lie. I can't get there without getting through this.
I understand.
Thank you.
Thank you. All right, members, how should we dispense of this? Should we continue it? Does it still seem unclear whether we have enough information? There has obviously been some delay, so there is that. The question is whether there are documents and records that are still out there in possession that are available for public disclosure, and identifying whether they are there or not. We're not really here to do an investigation of that per se, except to at least identify whether they exist. We don't have that. That's not our purview. So, what do you think? Move it up to the task force or continue it? And
I was looked over this and I left my binder at my desk at work, but as I was looking at this last night and this morning, I felt like we have enough information to go at some of the issues you just mentioned in terms of, I guess, kind of a timeliness of response and the scope of the response. There are a lot of requests at issue, 5 different kind of categories, and one of which includes, 21 requests, another one, several others that follow. But, it would be good to continue or to get some more documents out to the extent that there are responsive documents that haven't been produced. That would help eliminate the need for discussion of the task force for any one of these categories if we could move that along, but in terms of timeliness and I think some aspects of scope, I mean, I think there are things the task force could make determinations on as a whole.
So I guess the thing is identifying specifically for each request that Mr. Smith had made, which documents are being, would seem to be public, that would be in the possession of the museums, and without any response from them that it exists somewhere else in the city for Mr. Smith to go and get them, to determine whether they are actually in their possession or not, and to have them disclosed. That would be the first thing that I can see. The timeliness issue is, can be, fairly easy to determine. It's really a matter of, does the museum have this information or not? And if they want to withhold information, it's fine, but at least come with a reason for withholding them. And it can't just be because it's invasive. I mean, there's lots of things that's invasive, like the master voter file is invasive. There's a lot of information in there, but it's a public document.
Right.
So.
When would this be, and this is part of my, I don't know, hesitation, or I'm just confused a little bit about this process and how it goes from here to the task force.
Mm-hmm.
I mean, my understanding is, obviously, we've got a meeting next week, and it wouldn't be on that agenda.
Right.
So we're talking November, December?
Possibly.
Depending on scheduling, but it would be at least 5 weeks out.
Right.
And I assume that the parties, if they can supplement the record, but
Well, we have to either tell them what we want them to bring or not, and so it's that kind of thing. If the respondents are going to say we really don't have those documents, then there's not much that we can compel them to do without any further evidence that they exist. So that's kind of what some of the examples I was giving was that, there's some corroborating evidence somewhere else that is presented to us,
right.
Either through our own internal means or just obvious knowledge. It's obvious knowledge or not. So that's kind of where I'm at. I'm inclined to continue this because I want to have to. It's going to demand some homework, a little more homework than I've done, because I'm not clear that some of these documents, are not available. I mean, for me, it would just be looking at like index of records,
right?
Just to determine for any department, would these kinds of documents be, would they exist in a department or not, kind of thing. And frankly, maybe they don't exist in this department because they were never collected, they were never needed. That could be that too. But I'm compelled about this idea around the docents operating in the building, in the program, and there not being any documentation. There's liability issues, risk assessments with regards to people in, public property. And there's all kinds of policies for what can or cannot happen, with regards to that. What are people allowed to say? What are they not allowed to say?
Right.
How did they get ADA training? Did they get, there's all kinds of things that come into play here that may be a requirement as part of an MOU or what have you that might reveal some more information that Mr. Smith wants. Our job is to identify what information is public and what's not. We're not to go on necessarily a fishing expedition, but there's plenty here to go on.
Right.
We don't have to invent a whole lot. He's asked for quite a bit of stuff. We can ask for every single one of these requests, what exactly it is, but it has to be necessary with the person that knows about this stuff also. And so that's, would be my other question as to whether we need to ask for maybe Mr. Jones to appear, since he's the one that did it. Maybe he doesn't know, but maybe he knows somebody that does know. And we have to do a little bit of that. But I want to move this on because we're now way over time on this one item.
Okay, that's fine.
Is there a motion? Can you turn on Member Hensey's microphone, please? Oh, go ahead.
I'll move to continue the item
Okay.
to
Is
the
there a
call
second?
of the chair.
I'll second.
Okay, it's been moved by Member Hensey, second by Member Kate. Is there any public comment on this motion? So the motion is to
I'll move
continue the item
Continue the item to the call of the chair in this committee.
in this committee. We're going to identify some more of these particular items because we don't feel that enough information has been presented, and to provide a full record to the full task force. Otherwise, they'll end up being in a 2-hour session and going down a rabbit hole too. So. Please, I'll allow you to come and ask the question to us, but it's got to be in the microphone, okay?
Are you asking for more information from me?
No, we will notify both parties if we're asking for information from one or the other.
And am I allowed to get what they give the committee?
Absolutely.
Without asking for public records?
Absolutely.
It is automatically provided.
automatically
Anything we receive from one party is automatically provided to the other.
So I got this document that was just handed to me.
The agenda.
You mean
That was part of the packet, and it was already provided to you.
Electronic.
Yes.
Yes.
Yeah. Okay, thank you. Seeing no public comment, can we take this by acclamation? Seeing no objections? Thank you. And I apologize to everybody else. This is a very difficult item. Call the next item, please.
Item number 6, file number 18062, complaint filed by Jay Walker against the San Francisco Public Utilities Commissioner Vince Courtney and the San Francisco Public Utilities Commission for allegedly violating Administrative Code Section 6721 and 6724 by redacting records in an inappropriate manner.
Okay. Okay, let's have the complainant, petitioner.
Mr. Walker, are you in the room?
Mr. Walker, did you receive any communications from Mr. Walker?
We have not received any communications.
Oh,
Okay.
somebody was here earlier, but.
No, okay. Is the respondent here?
I'm the Deputy Director of HR with the Public Utilities Commission.
Okay, and is Commissioner Vince Courtney here?
No,
Will you be able to answer on his behalf?
I'll be able to answer on behalf of what we have provided.
That wasn't my question. He was named as in the request.
I'll do my best to answer on his behalf. I guess it will depend on the questions.
Okay, great. So you're here to also respond on behalf of the commission?
Correct.
Also, okay, great. Okay, all right. So the complainant alleges redaction of records that was inappropriate. Can you explain the redactions and under what rule or law or policy allowed you for that redaction?
Certainly. So we produced 57 responsive pages with various redactions. The redactions are pursuant to an exemption for personnel files, which is under Government Code Section 6254 sub C. That exemption is, the basis for that exemption is to protect the privacy interests of employees. So we redacted information and only information that related to core personnel matters such as performance or job status, things like that. to avoid an unwarranted invasion of privacy for our employees.
Okay, thank you. Members, any other questions?
Actually, I do have one question. And was the subject of the communications that led to the redactions, was that person terminated as a result of, I guess, the inquiries and the communications that were had, or otherwise kind of reprimanded?
Was the employee who was the subject of the communications?
Correct.
No, that person is still employed.
Were they reprimanded or kind of, I'd say, punished in any kind of way?
Not that I am aware of.
Okay.
Mr. Chairman,
Yeah.
since it is our standard to, if the complainant does not appear without prior notice, for us to file the matter.
Yeah.
However, if you do wish, it is at your discretion.
Yeah, I'm just asking some basic questions, just to determine whether, how far we should go on this.
Yes.
But we will, I guess we will, well, so we haven't heard from him at all.
I have not received any communications from Mr. Walker.
All right, so let's put this case on hold. I guess it would.
We could file it, and then we would send in communications giving them the option to
Okay,
reopen.
Then let's do that at this point, okay?
Good.
All right, should we,
May I ask what that means? What do you mean?
We would table this, file this matter, and if the complainant does not get back to us within 60 days, we will consider the matter closed and no longer active.
Okay, thank you.
okay.
Do we need a motion to
Yeah,
this
it'd
effect?
let's do that.
Sure, I'll move to close the file,
Second?
or table the file.
Second?
Just file.
Yes. Mr. Chairman, I'd just like to ask a question. If this person does get back to us, would you like this to come back to committee or go straight to the task force?
No, I would say send it back to committee because there
Okay.
may be more questions,
Thank you.
given his opportunity to be able to explain what it is exactly he was looking for.
Thanks.
Okay, any public comment on the motion to move this to file? Seeing no public comment, please call the roll.
Member Hensy?
Aye.
Member Hensy, aye. Member Kate?
Aye.
Member Kate, aye. Chair Wolf?
Aye,
Wolf, aye. The motion passes.
thank you. Please call the next item.
File number 18069, complaint filed by Mike Black against City Administrator Naomi Kelly and the Office of the City Administrator for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Let me ask, are both parties here?
I am not sure if he's in the hallway. He was here and dropped off a letter. I'm not sure if he's still in the hallway or not. I will check.
Okay, thank you. Is he there?
He is not here. However, when he was here, he did drop off a statement. I'm not sure if you would like that or not at this time.
Can I just see it, review it? Did they not provide this before the meeting?
He brought it into the meeting and handed it to me during the meeting.
Not accepted. All right. Okay, members, since the complainant is here, but the respondent isn't, even though the respondent was here earlier, would you like to, how would you like to dispense with this? We can continue it.
Was that document, was that intended to be read as a statement, as testimony?
More or less.
And was the respondent, I guess, left and didn't talk to anybody, didn't talk to anybody before?
Didn't tell you?
I did inform him that it was requested that he be present for testimony, but
All right.
Okay.
He did just leave. He didn't even.
Didn't say anything. Okay. All right. So how do you want to dispense with this? We can move forward in absentia, but the question is will we get enough information from the respondent? They could have sent this 10 days ago and said we're not going to be able to make it. Consider this for the record, and we could have continued. We could have gone forward with the proceeded. Usually, we give the gravity to the complainant so that they can have their day. We can continue this, reschedule it. Unfortunately, that will be, or if you want, I can expose this document. You want to take it into the record, and then we can continue with the case in absentia with the respondent in absentia.
I mean, I would just, out of just kind of deference to moving things along and to the complainant's time here, I mean, I wouldn't mind moving forward and seeing if we can proceed with what we have in front of us. I actually wouldn't be, and I know there may be some other
Right. So the
issues involved in taking that statement and kind of considering it tonight,
Right.
but I won't have a problem with it if there's a way we could get a copy to the complainant
Right.
and do that. That way we can at least
So
move on.
Okay, so if you want to accept this statement from the respondent into the record, then what I would suggest we do is we make it available to Mr. Black, and we table this item and to and take on another item in our agenda. We'll come back to it in this meeting to proceed. Sure, come on. Sure.
It really is, but I don't want to create a battle of printed statements. But I have a written statement I could submit as well as my statement for the evening, and just add those to the record.
No, I understand that, but usually that's not what we do. That's why I'm doing this, because it would be we can accept this as their testimony, and we can continue with the case in your to your advantage. Okay. To at least hear it today, and then get it onto the docket for the full task force. Okay.
Yeah, I would like to be able to do that. So whatever
Okay.
you think is going to make that possible.
Okay.
For sure, let's do that.
Great. So hold on. So we should do this by motion to accept this item. We're going to waive the rules for the 5-day requirement and allow this document to be accepted into the record. And then I'm going to let each of the members, do we have copies? Yes. I'll let everybody have a copy, and then we're going to table this item, and we'll hear this item after the next item. Okay?
Did you need a motion to waive the rules and accept the document beyond submitted inside of 5 days of the meeting?
Correct.
Second.
So moved by Member Kate, second by Member Hinsey. Is there any public comment? Seeing no public comment, this is more functional, operational. Can we take it by acclamation? Seeing no objection. Okay. Okay, and so at this time, let's call the next item.
Item number 8, complaint filed by
Can you grab
Joshua
the paper
Clip
for me?
against the Recreation and Parks Department for allegedly
Thank you.
violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay. We need to do determination, jurisdiction. Is there a motion to find jurisdiction?
So moved. To find jurisdiction.
You might want to provide a slight explanation for Member Kate, as this is his first time dealing with this.
Oh, okay. So what we do is, in order to comply, well, first of all, in general, we determine whether this is in our jurisdiction or not, to determine whether the complaint's in the right place. The second thing we do is to determine if the information is public or not. If it's a public records request, we have a requirement to do so within 45 days of receipt of the complaint. And that's basically what that starts the ball rolling. That allows us to actually move forward to hear the case.
Right.
So, here, if you read through the documents and you read through our legal counsel's memorandum, it's clear that this information would be public documents, possessed and contained, potentially contained, allegedly contained by a city department, and then the city department can determine, but can tell us whether it is or is not at that point.
I just want
Yeah.
to say something. Tiffany Lynn Whitney said that in the packet
Get
there was...
closer in the microphone.
Sorry. Tiffany Lynn said that there was a draft of this particular document in the packet. She sent it to us. She apologized, but she sent a final form copy, and I said I would make copies and bring them to the committee.
When did you receive them?
About 3 o'clock this afternoon. There was a draft in the package that she didn't realize she had included in her documents that she sent to us in response.
I'm not
We
saying,
received a draft version of this document, and she would like to replace it with a final version.
Oh, okay. So, well, then the question...
We probably need to vote on that at a later moment.
So, all right. So before we do that, okay, because we're just determining right now whether the matter is within our jurisdiction and whether the items are public or not. Okay, let's do that first. Then we can take up the issue of.
Second the motion on.
Okay.
That we have jurisdiction.
All right. So I'll be the mover of the.
I was.
Oh, you were? Okay.
Yeah.
I'm sorry, Member Hensey. So moved by Member Hensey, second by Member Kate. Is there any public comment on jurisdiction? Seeing no public comment, can we take that by acclamation? Or maybe we should take it by vote, right? Take
It's
it by
your choice.
acclamation?
We note the vote. We note the individual parties present, so that's
Okay,
fine.
so we'll take that by acclamation. Seeing no objection. Okay. Okay, now let's take up the issue of this new document. Is the respondent here from Rec and Park? Please come up. Can you tell us why the draft was not good enough or was not sufficient?
Yes, so my name is Tiffany Lynn Wilson. I am a secretary with the Recreation and Parks Department. The original draft document, when I had included it in the packet and I had opened up the document, it looked like it was the final draft and everything looked good. I sent it out, included everything, and when I went back to make sure that I had files for in preparation for tonight, and I went to go and print everything up, and it is that it was printing up a draft copy, and I was just completely blown away. So I reached out to Cheryl this afternoon and let her know that we did have a final copy after I had conferred with the city attorney's office, and I provided that to her. Was not sure whether or not that would be admissible, but I did provide what I could.
So is there a difference between the draft and the final?
The draft. The draft is it's more messy. It's definitely not as formal.
Is there anything substantive? Like, are there items in the final that were not in the draft that are substantive?
No, I don't believe so.
Okay, so there's nothing of great gravity that the complainant will object to?
No.
Okay, thank you. Mr. Klipp? How are you, sir?
Hungry.
I hear you. So they're requesting that the draft be replaced with this final report. And so would you like an opportunity to review it before we determine to either take it or not take it? I mean, we haven't seen it either. It's not been distributed to us yet.
Yeah, I noticed that there was that the draft copy seemed to have been provided, which I didn't totally understand. So I understand Tiffany's point. I haven't had an opportunity to look and see if there are, basically what it is her letter, but it had been interlineated by other, I suppose maybe other editors or by herself, and so you can track the changes. So track changes probably should have been turned off before it was submitted, but it seems like it wasn't. So I don't know if what is crossed out or whatever is substantive or not. I understand that she's in a tough position. I don't want to be the guy getting her in charge with her, getting her in trouble with her boss. So I'm not going to object to that.
Are you okay if we introduce the item? Well, the draft item will also be part of the record.
Right.
We're not necessarily replacing it. So.
Oh, gotcha. Okay. Yeah, no, I mean, if Tiffany says it's substantively the same, just minus all of basically the printed out track changes, I have no problem with that.
Okay. All right, fine. If along the way you find that there is something substantive that will make or break your case in some kind of way, it would be helpful for us to know.
Okay, I can look at it and let you know.
Okay, great. Let's have a motion to waive the rules and accept this item.
So moved. Second.
It's moved by Member Hensy, second by Member Kate. Is there any public comment? Seeing no public comment, can we take this by acclamation? Seeing no objection, please distribute. And we're not going to actually replace it. We're going to just add it to the record so that you can see them side by side.
Understood, thank you.
Okay, thank you. All right, so now we'll start with yourself while you're standing there and give you 5 minutes to explain your complaint and what you would like us to know.
Before my time begins, could I ask
Go ahead.
If the committee has already read my requests and reviewed the Rec and Parks responses? I'd preferably not spend my 5 minutes going over that, but if you need me to, I would be happy.
Well, again, our purpose here is to just make sure that there's enough information in discovery so that the task force can dig in deep and determine if there's a violation or not. We're not here to do adjudication today. We're only here to make sure that there's enough information in the file so that way when we get to the full task force, they're not fumbling around for documents that aren't there.
Okay. Then since my requests and their responses are part of that file, I won't go over that.
Okay, great. Is there anything that you would like to add?
Yeah. What I would like to add is that since 2008, the Urban Forestry Council has compiled an annual urban forest review. And this review asks any agency or entity within the city that has some responsibility for trees to submit a detailed report on things like their budgets, the number of trees removed, number of trees cared for and planted, and also includes a rated list of concerns regarding trees within those agencies' purviews. Responses to this report requests are voluntary, and the responses are then compiled into a report, which is publicly available on the San Francisco Department of the Environment's website. Every year since at least 2012, Rec and Park has submitted responses to the Urban Forestry Council for those annual reports, including numbers of trees planted, trees removed, and types of trees most commonly planted. Additionally, they've consistently stated serious concerns about tree loss due to age and disease, as well as concerns about ability to care for new and aging trees. If these 4 documents provided to me by Rec and Park are the only documents responsive to my request, this means that since 2012, either Rec and Park's responses to the Urban Forestry Council were entirely made up based on 0 documentation, or that Rec and Park did not fully respond to my request. If Rec and Park does not track tree removals and plantings by site and species, they could have told me that. They could have said, here's how we track them. Would you like that information instead? If they have no reforestation plan, they also could have said so. They could have indicated how they document reforestation efforts and asked if I would have liked that information instead. Also, if Rec and Park has no documentation regarding planned removals in the next 5 to 10 years, then I'm unclear why they consistently report to the Urban Forestry Council that they are very concerned about tree loss due to age and disease. Why is that their concern, and then why is there no documentation around it? Based on publicly available information contained in the Urban Forestry Council's annual reports, it's clear that either the Rec and Park Department either did not provide all the documentation that it has that is responsive to my request, or alternatively, they are creating information out of thin air and giving it to the Urban Forestry Council for their annual reports. This is why I filed my complaint and request this committee and ultimately the task force to compel the Rec and Park Department to comply with the law, providing me with the right to ask for this documentation.
Thank you very much. Respondent, you have 5 minutes. Oh, I'm sorry. Is that all your testimony? So you have 2.5 minutes left.
It's been a long night for the whole committee. No, I think I covered it.
Okay, thank you. Okay, respondent, please reset the clock.
So I gather the information as the Secretary of the Recreation and Park Department. I gather the information. I do not hold the information. I'm not in urban forestry. I'm not a tree topper. I don't work on the strategic plan. The documents that I've provided are all documents that I requested from employees that have any sort of work with any of these reports. So I reached out to our analysts regarding the strategic plan. I've reached out to our Director of Operations. I've reached out to employees in the urban forestry. The documents that were provided to me were disclosed. They were not redacted in any way, shape, or form. As far as the timeline, I did ask Mr. Clip if he was interested in any of the trees based on a particular site-by-site basis, because we may be able to track down information that way. We have over 4,000 acres of land that the Recreation and Park Department is in charge of. And, so I did ask if there was a particular site that he was interested in. But some of the information is available via, on our website. It's online. It's readily available through the Capital and Planning website. That is where I would assume the Urban Forestry Council information does come from, as far as, replanting. But what I provided was what we had. I did not get a response based on my question for the site-to-site basis, so I wasn't sure how to respond to that. That's about it.
Does that conclude your testimony?
Yes.
Thank you. Questions? Microphone, please, Cheryl.
Did you direct the petitioner to that website as part of your response?
Well, I asked the petitioner on a site-by-site basis what he's interested in. I did explain, we have other projects that I might be able to find based on whatever site he's interested in. He did ask if there was a particular website that all of that is housed in. It's not something that they actively track. They are separate projects based on the Capital and Planning Department with different project managers.
So It sounds like he was trying to find information that goes back to 2012 or longer.
It just said over the last 10 years.
Okay, so the last 10 years. Does it sounded like from his testimony that there's a requirement for Rec and Park to provide information to the Urban Forestry Council. Is that correct?
I was not aware of that until he had put that in his follow-up response for the request. And when he did bring that up to me, I asked the Director of Operations as well as the Urban Forestry person whether or not, we did have that. And at the time, that document for this year did not exist. So I kept the request open.
What about the previous years?
I was not given anything. Mr. Clip said that he had access to that information, but that document would not be fully responsive to his request. And he did state that if he didn't, he stated that if the department does not have fully responsive documentation to his request, that he would appreciate affirmative acknowledgement of it. To which I did respond, this is all we have. We don't have any other responsive documents.
Doesn't it seem odd, though, that if there's a requirement for reporting to the Urban Forestry Council, that there has to be going back 10 years, which is not very far. It's not a very long time.
I can totally understand that.
And so, is there no one else in Rec and Park in the department that would have knowledge of this directly?
Not to the Urban Forestry Council, no.
So of the records that you know of, first of all, are there any reports going to Urban Forestry Council?
There is a documentation that was provided this year,
and who created that?
This was created by Kelly Cornell.
Okay, and is that the person that usually does this kind of work?
Yes.
Okay, and did you contact Mr. Cornell?
Yes, I did.
And did you ask him about the previous years?
I asked him about this fiscal year or about this year's because that was what was asked for.
One moment, please.
So the Urban Forestry Council.
One moment,
Sorry.
please.
Is that in the packet?
That is in the packet.
Okay.
One moment, please. So on page 273 is the request through the next request system that states the request is for all documents that show over the last 10 years.
So that was the original request.
Right.
It did not list the Urban Forestry Council report. The Urban Forestry Council report was asked for after I had asked
So
on a site-by-site basis.
let me ask some. What is contained in the Urban Forestry report?
It is.
Just give me a few items.
Sure. It's got the workforce, budget, health and diversity of the urban forest.
Does it show how many trees have been removed or location? Is there a requirement for that in that document?
There is, under tree care, it does say how many were removed, how many were cared for, and how many were planted.
Okay. And you're aware, I've done a little research on this in preparation, you're aware that there is a policy requiring a commission approval for removal or determining sick trees and removal of trees?
No, I was not aware of that.
Okay. So there's supposed to be some public hearings for such things. There are arborists that work that specifically work in the Rec and Park Department or are hired by them?
I don't know if that's their particular title. I can't say.
Well, people who maintain the trees.
Yes.
Okay.
People who maintain trees.
So people who maintain it's a park, so
Yes.
we're talking about inventory, and it's well known that there's been inventory of many areas of the park, and also determining, like when the Natural Areas Program wants to cut down trees, they count how many trees are to be cut down. There's an exact number, and they're all identified. So there obviously seems to be some documentation around trees that are alive and well and healthy and those that are not, and those that are slated to be felled. So I'm just wondering, who would in the department have that information?
From what I was told, like I said, I reached out to our director of operations. I was told Kelly Cornell would have this information.
Okay, but you don't have any further information yourself. That's all you got. Okay.
This is what I was given, and whatever I was given was presented.
Okay. Okay. Thank you very much.
Mm-hmm.
Okay. All right, members. Any other questions? All right. I'm inclined. I'm compelled by Mr. Clipp's request here, and the limited amount of information that was provided, considering the history of Rec and Park Department with regards to trees being removed and the policies and the Urban Forest Council reports and whatnot. I think it demands that the representative on behalf of Rec and Park Department has limited information on this. It was purely just collecting the information, doesn't have direct knowledge, and I think we should request that the actual custodian of the record be present, or compel them to provide this information for hearing to the task force.
I agree.
Could we, yeah, you say do both. Ask the custodian to look for and produce and try again, because it does seem that I hate to call it the raw data because that's not exactly accurate, but the data that goes into the report that the Urban Forestry Council gets.
The information that was requested.
Right.
Yeah.
For them to look for that information, specifically that custodian who would most likely have it, and to produce it, and ideally, hopefully maybe do away with the need for the task force to deal with this complaint if the complainant wants to withdraw. But in the meantime, go ahead and tee it up for the task force.
Right. And the Urban Forestry Council report is not specified in here, but the fact that it exists and it would have this information, it would be obvious that all the data that was collected would go in there.
The submissions to the
Right. And if for some reason they didn't provide a report to the Urban Forestry Council, is neither here nor there. The request is for the information that would possibly be in it. It could be other information that's not required to be in it too. So let's focus not on the Urban Forestry report. I think it was an interesting addition that the petitioner had brought forward, but I think clearly the information, we should find out and know if this information is inventoried, if it's collected on a regular basis, so on and so forth. This is not it's not like a wilderness area. Things grow like the way they're supposed to grow, okay? This is a park, it's manicured, they make specific decisions to install or remove trees, things like that. And there has to be some public notice for, I'm not sure if it's all trees, but for certain, if not most, trees that are to be felled, as to why those trees would be. Lots of times it could be a historical tree or a legacy tree that's like 100 feet tall. Even though it's it's not bothering anybody, it's not in the middle anywhere, it requires, because of its age, that kind of thing. So, okay, so if there's a motion to move this up to the task force, happy to receive it.
Second.
It's moved by Member Hinsey, second by Member Kate, and this would include the request for appearance by Mr. Cornell, and that the documentation for the previous 10 years be provided. And if not provided, a reason why. Okay. All right. Any public comment on this motion? Seeing no public comment, please call the roll.
Aye. Aye.
Member Hinsey, aye. Member Kate?
Aye.
Member Kate, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Thank you.
And we also like to note that Member Tesfa is absent.
Yes, member testifies absent. Okay, let's bring back.
Just
Yeah.
just for the other parties, we will notify you when this matter is scheduled. I don't anticipate October, so possibly November or December. We will keep you informed.
Thank you. And sorry for how late this meeting has gone. Okay, let's bring back item number 7, file number 18069. Yeah.
Item number 7, 18069, complaint filed by Mike Black against City Administrator Naomi Kelly and the Office of the City Administrator for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, did we take
You
take
have-
action on jurisdiction?
You have not.
Have not. Okay, so let's do that first. Is there a motion to find a jurisdiction?
So moved.
Second.
Okay, any public comment on that? Not including the party. Seeing no public for public comment, can we take this by acclamation? Seeing no objection, item is approved.
Call the roll.
And this would also, I'm sorry, this would also include the 45-day rule, the public,
Okay.
that's, the information is public. Okay, so let's get to the hearing part. Let's ask Mr. Black, did you have some time to read through it?
Yeah, can I tell you what I'd like to do? Can I just read my prepared statement? It's short. I mean, I tried to make it, under 4.5 minutes. Then it may be clear or obvious to you why I find Mr. Barnes' letter a complete puzzle. The two statements have nothing to do with each other almost.
But are you comfortable with that the statement's been included in the record? Does it?
Yes. Yes.
So you're prepared. You're prepared to move forward.
Right,
Okay.
I'm just puzzled
Great.
by the statement.
Okay, great. So let's start the clock for him at 5 minutes. And let's. So we're going to. So just so everybody knows, and for the public, we've accepted the city administrator's statement in writing as their official testimony for this hearing today, and that we are moving forward with the city administrator physically in absentia, and then we'll make a determination thereafter to how to dispense with this. Okay, start the clock, please. Restart the clock.
On the morning of August 30th, 2018, a Thursday, I submitted an immediate disclosure request to the city administrator's office at the city.administrator@sfgov.org email address. I received no response of any kind by the end of business on the following day, Friday, August 31st. That weekend was the long Labor Day weekend, so I waited until 11:08 a.m. on Tuesday, September 4th, to email the city administrator's office again, asking about the status of my IDR. This time I copied in the city administrator, Naomi Kelly herself, as well as Bill Barnes of the city administrator's office, and still I received no response of any kind all day. Eventually I filed this complaint with the task force at 7:43 p.m. that Tuesday evening. Finally, at 5:25 p.m. the next day, Wednesday, September 5th, I received an email response from Bill Barnes. That response is peculiar for a couple of reasons, but first please just note that the facts present a clear violation of Section 67.25A and B of the ordinance. As to the peculiarities, the first is the assertion by Mr. Barnes that the city administrator email address I used is not, quote, routinely monitored for public records requests, unquote. He states that an automatic reply responds to such emails, an automatic reply that advises the sender that other email addresses should be used for public records requests. That statement implies, of course, that in some sense, emails are routinely monitored, if only automatically. What's more, I did go back to double check and couldn't find anywhere on the city administrator's website the email addresses Mr. Barnes says should be used for records requests, and I've taken screenshots of those relevant pages. In any event, I did not receive that or any other response to my IDR. Compare the two previous IDRs I just recently submitted to the city administrator at sfgov.org address, one on July 2nd and one on July 27th. In both instances, I received timely responses from Mr. Barnes himself before the close of business on the next business day. Now, in that second IDR on July 27th, I did include Bill Barnes as an addressee, But in neither case did Mr. Barnes ever advise me that I should be using another email address for public records requests. Moreover, my follow-up email of inquiry on the morning of September 4th with regard to the present IDR was also copied, as I said, to both City Administrator Kelly and Mr. Barnes, and the substance of my email made it obvious that I had not received any reply. And yet they still completely ignored the IDR, refusing to identify any perceived error on my part or theirs until after I complained to this task force and after the close of business on the following day, September 5th. That violates not just the letter of the ordinance, but also its spirit of cooperation with citizens seeking public records. And finally, I just really briefly want to address Mr. Barnes' enigmatic response to the substance of my IDR. It wasn't clear to me if he was asserting that the city administrator's office has records that are responsive to my request, but that all of them are exempt to disclosure under attorney-client privilege. I never received an answer to that question, and indeed have received no further response whatsoever from the city administrator's office, not even in the packet for the hearing, until this evening. Assuming that the city administrator is withholding all responsive records under the attorney-client privilege in this instance, I've already submitted to the task force written arguments and documents refuting this claimed blanket privilege. I was only requesting copies of written communications between the city administrator's office and the controller's office, neither of which acts as legal counsel to the other. Furthermore, as I know from responses to other IDRs, there were at least 2 responsive documents that the city administrator's office failed to provide, and I produced copies of those for the task force. And while one, and only one of those, was an email that had attorney-client privilege communication in the subject line, not only was there clearly no basis for putting that on the email, the fact that it was produced despite the claimed privilege constitutes a waiver of the privilege under Government Code Section 6254.5 of the California Public Records Act. And then I don't even know, I'm just kind of flummoxed by Mr. Barnes' letter, which deals completely with the whistleblower provisions. Oh, thank you. I'm here, I digress. I'm here every week recording, and my big bugaboo is that nobody speaks into the microphone, so I appreciate your... and so I'm not sure what to say. I'm just kind of, it sounds provisional. It was mentioned in his original reply to me. He only expressly invoked the attorney-client privilege for documents he said they were withholding. The controllers, this.
Finish your thought.
So this matter of the whistleblower program, the controllers, right to withhold all kinds of documents as part of that, I thought was boilerplate because the way it was phrased was provisional. Like, if we have any such things, maybe we're withholding it. And I don't know if that's because the whistleblower program is supposed to be a completely secret one, so you can't even let people know if there is a whistleblower. But in this particular case, I have to tell you, I don't know who else the whistleblower would be besides me. I'm not a city employee, or a police officer who kind of blew the whistle on one of the hearing officers. So I really am confused by this. I don't know what to say in response to this.
Thank you. Okay, members.
When you submitted your IDR, did you get an automatic reply at all?
No.
Okay.
No reply at all.
Okay.
And when did you get a reply, a response from them?
Okay, so the IDR was the morning of August 30th, which was the Thursday. I got a reply from Mr. Barnes after 5 o'clock on the 5th of September, a Wednesday.
Okay, and I'm sorry, please repeat to me what was his response.
It's in the record. I actually have a copy of it.
Can you tell us what page it's on?
Oh, I wish I could.
241?
It's towards the back. I think it's like the third from the end.
Got it.
241 was September 5:25 p.m.
Oh, 241, okay. Past it. 245, 241, here it is. Okay, I have this. Yeah, it's fine. Dear Mr. Mike Black, I'm in receipt of your request, September 4th, which I'm treating as a major closure, due today is September 5th. Okay, I see.
I don't know if I sent him an email asking what he meant, because I wasn't sure what he meant exactly.
Well, the thing is, a lot of departments set up a specific process flow for general requests that come in for the department, not for a particular person. Otherwise, you send it to them directly by name, right? So if it comes into a regular request and you sent it in to cityadministrator.sf.gov, but really it needed to go to admin sunshine requests, question is was that information available anywhere? Is it available on their website? Was it available when you called them? Was it available in some brochure documentation?
To be completely candid, it takes a little explanation. The first time I submitted any kind of public records request to the city administrator's office was last summer, July of 2017. Did a couple of requests. I had a different address at that time that I used. I since have gone back and found it. And so I used this special address. I forget what it is. I think maybe it's admin, something like you said.
Okay.
So when I decided to do a request in July, I couldn't find it any place on the website. It just, I had found it originally on the website, but I couldn't find it, so that's why I resorted to city.administrator, this general email address. And as I just detailed, twice in July, I got a very prompt, timely, legal response to those immediate disclosure requests.
So that you knew that email address worked.
Yeah, it worked, and nobody
Okay.
said anything to me. Mr. Barnes was the one who responded to those, and he never said, "Oh, this is all very nice, Mr. Black."
So he responded in July to that address?
Yeah. Yes.
But now he's claiming in September that it's supposed to be a different address?
Twice he replied in July.
Okay. All right.
Without advising me that there was a different or better address.
I have a quick question, and
Go
you
ahead.
may have already said this, and apologize if you did, but when you sent the initial request, I think August 30th, did you just send it to the city administrator email, or did you
That was it.
just the sole? Okay.
City.administrator@sf.gov.org. Because it had worked.
Right.
Well, and again, I mentioned I have screenshots. What is today? Tuesday. Sunday, I went back to double check, and they have a contact page. The city administrator's website has a contact page. That address is no longer there. That's where I think I originally got it a year ago, but it's no longer there. Then they have a public records tab that you can click on. But what it takes you to is a page where you just put in the records you're looking for, and it's all automated, and it pulls up any records they have online.
It's just a search engine for
Yeah,
their
search
website?
Exactly, for public records.
Oh, okay.
That's what takes you. That's where you're taken with the public records tab.
Oh, that's interesting. Okay. Well, if all records were there, then you would have the records that you want, right?
Well, yes, well, I assume
I'm
you're
being
saying that,
facetious, but
because,
yes.
most of the kind of records that I've been requesting, a lot of people request are
Yeah.
emails that never get.
Yeah, no, I hear you. Okay, so, all right. So the request was made on August 30th, and what time of day was that? Really doesn't quite matter, but
It was, I don't have the time, I think it was 10.
it was in the just morning? Okay,
Yeah,
okay.
yeah, it's definitely in the morning.
So the requirements for IDR is that a response needs to be made by the end of the following business day. Considering the long weekend, that would have been Tuesday.
Well, no, Friday was the response date.
Because it was.
Oh, the 30th was a Thursday?
30th was a Thursday, 31st
Oh.
was a Friday.
Oh, okay.
But, when I realized I didn't get a response, all
Got
I
it.
did was wait.
Okay, so that, okay.
But I did wait till late morning on Tuesday, the 4th of September, only because I thought, well, it's a holiday, people aren't always doing things the way they're supposed to do things around the holidays, so it wasn't like I got up first thing Tuesday morning. I waited a couple of hours thinking maybe something would come through. But I honestly was shocked when nothing came in all day. I've had plenty of email communications with Mr. Barnes. Plenty.
Okay. And so under 6725, a response shall be inquiry no examiner should be satisfied This deadline, top of the subject line. Oh, wow. Did he state that when he did make his response? Let me see. Do we have that?
You have a copy.
We have a copy of that. So that's on page 241. Okay. So we have conducted diligent, thorough search. We have withheld records, responsive.
I mean, he's just deciding when the immediate disclosure request began. On what basis, I don't know. Because he never acknowledged the receipt of the email on Tuesday before.
Well, but he acknowledges it in his opening sentence. I'm in receipt of your request received on September 4th,
You're right.
in which I am treating as an IDR
Yeah, you're correct.
and due today. But your request was not. It was received on the 4th, but it was made on August 30th. That's the issue here. Okay.
Sent a follow-up
Sent a follow-up.
on the 4th.
Yeah,
Right.
Yeah, so he sent on the 30th, and then he sent it again after he didn't hear anything.
Miss.
And that's,
Oh, okay, gotcha. Okay, so
Mr. Black sent a follow-up on the 4th, and that's the one that Mr. Barnes says I've received.
right.
that
So here
one.
on the morning of the 30th, I
Kind of
submitted.
skipping over
Right.
August 30th.
So
explaining-
basically,
Right.
it disappeared into the ether, the original. Okay. All right. Okay. So I suggest that we focus on that. With regards to, so there are two issues here. One is the responsiveness under 6725, timeliness of response, and then the actual information. So they're citing various laws with regards to the whistleblower unit. Okay, and so based upon that, there's not much that we can do. Okay, the question is determining. The hard part for us is because we're not like a real court where a judge can see things in camera so that they're not revealed publicly to any of the parties. We can't tell what documents what they are. That they're just citing that they can be withheld.
But just to make a point that is in all my papers, they have in fact provided me 2 documents that are responsive to this IDR
Right.
that they have not invoked either one of these privileges for, either this whistleblower thing or the attorney-client privilege.
Okay, but they're saying
This was to a
they're saying prior. I understand that, but we're only talking about this request.
Right.
We're not talking about any other request or any other documents you may have received out before this request. Okay, so that's not part and parcel.
But why wasn't I provided those documents to this IDR then? If we're not going to, forget about that previous IDR. We have this IDR. Why are those 2 documents which are responsive, which I know exist, not produced to me by the city administrator?
Well, I'm not following it. Were you expecting to get the same documents?
Of course.
I don't understand. If you already have the documents, and why are you asking for them
I
again?
don't think they knew that they were, I don't think they, I have no faith that they're looking through their documents. They're looking through us, it's a whole stack of documents I got. They're not looking through those and say, oh, well, we already produced this for Mr. Black, so we don't have to produce that. That's not represented. When that has happened in the past,
Mr. Black, I'm very confused now. The 2 documents that you're referring to, that you're stating they should have provided you in this IDR, documents that you had received before, okay? How do you know that those 2 documents would have been applicable to your request, to this new IDR request? How do you know that?
I state parameters in my IDR. I would like communications from this date to this date that concern this subject. And those were exactly what these 2 documents were.
So you already had them before, and you asked for them again?
I wasn't just specifically looking for those 2 documents. I was looking for a whole range of documents.
Okay.
But, you know, when they came back and said, we don't have anything, but, you know, I had to go looking through my own documents, so I know they didn't.
Okay, okay.
And I found 2 documents that were in fact
So,
responsive.
so you did you submit those
Yes.
copies? Okay,
They're in
so
the packet.
so there are responsive documents.
You know, the date range was April 26th to June 29th, and this is an April 27th email between the city administrator and the controller's office, and one on May 1st between those 2.
Let me ask you, were these duplicate requests? Did you make a previous request, it's the same request?
It was a different request, but there's some overlap because it has to do with
Okay.
hearing officers.
I got you. I just want to be cautious
not-
because sometimes folks will say, he already asked for that, we already gave him those documents. We know we gave him those documents, there just weren't any further documents. So you're saying the previous request for something completely different subject, but documents may have overlapped.
Right, there were overlapping documents because there was some subject matter that was related.
Okay.
Yeah.
All right, great. Okay. Anything else, members? Do we have enough information to move this up to the task force?
I think we do.
Okay. All right, and I guess trying to figure out what what is being withheld is going to be somewhat of a sticky wicket.
Right.
We always have to deal with that because we can't see anything in camera, and you know, unless we get something corroborating from the city attorney or something like that, that you know they pretty much can't lie about it, but that the documents cannot be withheld. We can request that.
May I just point out that for once I really read your, not for once, I've done it before. I read the packet pretty well, especially I was interested in the city attorney's statement and their analysis. And for once, I thought they did a really good job. And so I would point out that one of the things that I raised that he makes a point of saying is an issue in this case is this whole attorney-client privilege thing. Because one of the documents that was produced had attorney-client privilege on it. And yet
So now it's
that was
public.
waived.
Right.
Okay, so that's an interesting.
Whether
That's very good.
The
piece of
scope of that
information.
waiver and whether it applies to.
Right. Well, I don't know, we've heard arguments that even though something that the public may get wind of attorney-client, the attorney-client privilege is still, we dealt with this with a previous case recently, actually, where that happened.
I mean, is there a way that, because I think there's the factual issue you mentioned about not knowing, obviously, what's behind the assertion of privilege, of which documents and what they're saying is privilege. It's going to be hard for us to know that, but I'm curious, there's like the legal issue as well that's at least, mentioned in the letter we got today about Appendix F and the city charter and the notes and drafts of the controller's investigation shall be confidential. And I'd just be curious if there's a way we can get, the city attorney's advice on this about the interplay between that quoted section in Appendix F and how it applies not just to the ordinance, which seems to be kind of, I won't say vacated, but kind of overwritten by this language in Appendix F, but then it also talks about, except to the extent required by state or federal law, and I don't know if that brings back in,
well,
the PRA and whether.
Yeah, that would be a question for our legal counsel.
Right.
Obviously, you're an attorney too. I think you may not be versed in this particular area of law, but at least can help with the logic around it. That would be
it's not
helpful.
promising in terms of a finding that.
Can I ask you a question?
Yeah.
Yeah, because you say you're an attorney. So I would like someone to confirm my reading of this, Mr. Barnes' letter this evening. My reading is that he's very carefully avoiding saying documents are being withheld because of a whistleblower investigation.
Did he not say that in his, I thought he said that in his response on
did.
September I mean, it's not a very fulsome explanation, but
He does mention
we
it.
have withheld records responsive on the basis of attorney-client privilege.
Right, for that.
Citations.
But then you get to the part about the whistleblower thing, and it's to the extent
Right.
we have any documents which relate to possible complaints.
Right.
And in the letter tonight, it's pursuant to this section, if any, would be confidential. If any would be. So it's not clear to me if this is necessary language because you're not supposed to acknowledge that there's a whistleblower, or if it's just
Right.
waffling, just plain old waffling.
Right. Well, so. I just find it interesting, though, that you're asking for certain information that doesn't necessarily specify that it's a whistleblower case. And now they're bringing up that it is a whistleblower case that's being managed by the controller's office. There's only two places a whistleblower case can exist, and that's either in controller's office or the ethics commission. That's the only two places. So, and generally when it goes to the controller, it's dealing with finances. The ethics deals with conduct or other items. So,
I know my skepticism buys me nothing, but I'm very skeptical.
no, I understand that, but it's,
Yeah.
we don't deal in
Yeah.
skepticism, so, the thing is, we try to at least deal with facts that are corroborated, and if we're not able to do that, then we end up at a kind of a brick wall, and there are other remedies for you, which would probably be a court or the ethics commission, because the ethics commission is a legal body, in a way that they can actually do enforcement, so they have liability attached to them, gives them a little more gravity. But they also have a different kind of process for discovery, which is done in secret. That's done more, with more investigative. Not so much powers, but process. They do a little. We do things out in the open, but we don't. We'll only investigate based upon what's corroborating, what's available, what's not available, what's presented to us. We don't actually go out and investigate. They will. So it's a little different process. And sometimes if we find that there's something that demands that, then we have the option to forward a case to, if we reached our limits or we decide that enforcement is required or necessary, then we can refer it to the ethics commission, and they will accept it. We have an agreement with them.
In the interest of being candid and open with you, I have ethics commission complaints pending, both against and
On the same subject?
Yes.
Okay. Well,
Not on. I'm trying to think on this particular. I don't know about this particular IDR, but certainly it's about documents. Most of the.
well, it's not about whether it's an ID. Well, the question here is your complaint about a violation of the process of IDR, or is it a complaint about records not being disclosed, or both?
I had gone to the ethics commission when I thought it was willful misconduct, and it didn't involve me just getting a document.
Okay. So I'm asking you specifically because that will help us determine whether to move this case forward or to wait.
Okay.
Because if you've got a case that is pending in two different venues for the same thing, then we may want to opt to wait.
Okay.
Because that commission has a different level of authority than we do. It's a question.
Oh, that's a question to
Yeah.
you? I have to. The original complaint against the city administrator's office was for different conduct in response to another IDR, but that creates a record. And when there's been subsequent misconduct in my eyes by the city administrator's office, I have added that information to the pending complaint with the ethics So if that makes a difference.
But is it identical to the complaint you brought to us to us? As far as the records are concerned?
Mostly. There are other issues involved that like the hiring of hearing officers, that's not involved.
In the ethics case?
Right.
Is there let me ask, the case that you bring to us today, is that inclusive? Is all of it inclusive of the case at the Ethics Commission?
No.
Okay, then then we should continue with this case on our own. Okay, I'm just going to take that as your definitive answer. Okay, I don't want to belabor this too much longer. Okay, what shall we do? Is there a motion?
And are the options, is it the options are to just to take it up before the full task force on the IDR issue, or also the substance, or both?
Well,
or?
it's both. He's saying that he feels that the information, first of all, he's got documents that are responsive they received before from a different request that are responsive to this request, and he would have expected to have received those same documents as being responsive.
Right.
Okay, so they're now saying that they're withholding those documents, but they've already been made public. So why didn't they provide them those same documents? They can't now claim, based upon the citations of law, that they're now protected when they've already been released into the public domain. So that's a question that.
And so
they
then
need to
really it's
answer.
just, do we feel as the committee that we have enough to then push it up,
Right.
not so much the.
Right, and let the
Yep.
task force deliberate it and be able to ask those questions confidently.
And then as part of that process, the complainant and respondent both get an opportunity again to kind of add to, because.
And they have a rebuttal, and they can bring witnesses, and there'll be public comment. I mean, it's a whole.
I mean, I think we're ready. I think the task force can consider this. I keep looking at this Appendix F, and I'm starting to see some issues. But I think that it can be discussed with what we have, and ideally, if anybody's got any information, respondent or complainant, to move it along, that'll just help. But I think the task force is ready, and I would, if you need a motion.
Okay, yes, we need a motion.
I would move to submit it, I guess, to the task force.
Okay, great. Is there a second?
I'll second.
Okay, it's been moved by Member Kate, seconded by Member Hinsey. Is there any public comment? Seeing no public comment, please call the roll.
Member Kate.
Aye.
Member Kate, aye. Member Hensy.
Aye.
Hensy, aye. Chair Wolf.
Aye.
Chair Wolf, aye, and the motion passes.
And we'd like to note that Member Tesfa is absent.
And Member Tesfaye is absent. Right. Okay. Thank you very much. Okay. That's all right. Please call the next item.
Next item, item number 9, adjournment.
Is there a motion to adjourn?
So moved.
I'm hungry, dude.
Second. Sorry.
Moved by Member Hinsey, seconded by Member Kate. All those in favor say aye.
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 Aye. We are adjourned. 8:07.
First things first, turn off the recorder. The recorder first. Still recording. Yes, it is. That's by minute. It's not going to keep running because it's by minute.